And I would think into the facility is on property owned, used, or controlled.
Judge,
So,
just my 2 cents on that, coming from a C- lawyer. I would just say that to take something into,
who are you talking to? Which one of the lawyers are you talking about now?
Myself.
Oh,
To take a controlled substance into a facility necessarily implies that you possessed it to take it, Judge.
all right. I need a file here on Bridget. You're Bridget Wedlo?
Yes.
26 CR 133 is called the State of Texas versus Bridget Wedlo. That is you.
She brought weed into the county jail sounds simple, right? Nope. Watch 2 lawyers and a judge spend the next 10 minutes arguing about a comma, basically, because the indictment might have been written wrong.
Present with Ms. Manaldi, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? And we proceed in summary.
Yes, Judge.
In summary, this indictment alleges that on or about December 2nd, 2024 in Jefferson County, Texas, you committed third-degree felony of having a prohibited substance in a correctional facility, namely marijuana. You brought into the jail, Jefferson County Jail. You understand what you're charged with?
Yes.
Now, this is a third-degree felony, which carries with it up to 10 years confinement in prison. And an agreement has been pleading guilty to the lesser included offense of illegal possession of marijuana, a Class B misdemeanor. Just want to make sure, is this going to work under this indictment?
I believe.
I don't know.
But that-
No, the indictment says intentionally and knowingly take a controlled substance, namely marijuana, into the jail. Is that going to be covered under illegal possession of marijuana under the elements? That's all I want to ask. I don't know.
I mean,
The allegation, we're doing a lesser included from intentionally and knowingly take a controlled substance, namely marijuana, into the Jefferson County facility. I mean, that is going to match up with illegal possession of marijuana, which are the elements that we're looking at. I don't think I've ever done a lesser included like this, but it might work. What do y'all think?
I'm not sure it's going to fit, Judge. This is, I'm going to do this. I'm just not sure it's going to fit. Who was? No.
he thinks it is. I think it's not.
See, it's under the Controlled Substances Act, isn't it? So,
It's under, well, 3811 is what it's under. Prohibited substances in housing correctional facility. This says G, but there's a way they could have alleged it where they possessed it while they were in the jail. That's what then, that would have worked. This is
The
tape.
tapes is
Don't.
well,
3811C is tapes.
that's 3811B, isn't it?
B is for alcohol, Judge. C is for controlled substances.
Now, it says takes alcoholic beverage, controlled substance, or dangerous drug into a correctional facility is subpart B.
Okay? In plain English, the charge she's facing says took drugs into the jail, but the lesser charge they want to plead down to is just possession. The judge is basically asking, does taking something in automatically count as possessing it? That's the whole fight right here.
Then C is controlled substance and also dangerous drug.
Into property owned, used, or controlled. Prohibits a person provides or possesses with intent to provide. Okay, let's see.
I don't know if we can move that and say take it and say possess, but that's a whole different section. But taking would be, you have to possess it to take it.
That's my argument.
Point, Your Honor. I'm the one that created this situation, Judge. I apologize. My breath. I was upstairs working on the trial. So I took the stairs down. Judge, if you don't believe it is, I was watching on YouTube. If you don't believe it's a true lesser included, I would suggest that we do an oral.
No, I question it. It's just
I would
We
suggest.
don't want to pay for the same real estate twice. So
Well, could we do an oral amendment to the indictment, Judge?
see, this one is a bar exam question because the indictment alleges a crime under 3811. The person commits an offense if the person provides or possesses with intent to provide. C, subpart C. A person commits an offense if the person takes a controlled substance on property owned, used, or controlled by a correctional facility, and into. What's that? And I would think into the facility is on property owned, used, or controlled.
Judge,
So,
just my 2 cents on that, coming from a C- lawyer. I would just say that to take something into,
who are you talking to? Which one of the lawyers are you talking about now?
Myself.
Oh, wow.
To take a controlled substance into a facility necessarily implies that you possessed it to take it, Judge. Well, I think we can cure.
But it's under subpart B under section 3811, and you're stating section 3811G.
I think we can cure any questions, Judge, if we just do an oral amendment. If defense counsel is not opposed to us doing an oral amendment to the indictment, and I think we can cure also.
So that would cut either can't prove with witness or something else.
Yeah.
Fingers in my ears.
Why not? I think that could work.
We're fine with that, Judge. It's the same resolution
And-
to us, for us regardless.
What you're doing is, it's, you're bumping it to a misdemeanor that
Whatever, however,
the DA's office, the executive branch of government would be controlling, not the grand jury. And this is word for word a crime under person under subpart B under section 3811. A person commits an offense if the person takes a controlled substance into a correctional facility. And that's what it's alleging, word for word, and that's subpart B under section 3811. And this indictment is captioned section 3811 subpart G, which is just the offense.
Well, the caption, as the court's aware, it's not substantive.
It's obvious what the grand jury intended, that it fall under that statute, and
We'd like to just orally amend the indictment, Judge,
to
to possessing as opposed to taking, possessing in a correctional facility, or just strike the rest of that correctional facility altogether and just possessing marijuana, and then strike the rest of that marijuana, Judge. To intentionally, knowingly possess a controlled substance, namely marijuana, and just strike the rest of that, Judge. And I don't think defense counsel would be opposed to having the objection to
and
that.
then that would be the same result of giving to the lesser included.
And anything above the quote unquote line, as far as the caption, is not controlled, Judge. As far as the statute that's cited above the lines in the indictment.
but okay, so then what you're doing now is going under the Controlled Substances Act, not under the penal codes.
Yes, sir.
But, so now just statute is word for word under that section that was indicted is word for word under subpart B, which ought to be enough. I mean, it's the same statute to be proper lesser included.
How are the court seats to her?
However you prefer, Judge.
Yeah.
Either way, she's not having to plead to the indictment. It's still the lesser included.
Yes, sir.
Okay, we're going to change this to 3811 subpart B.
Yes, sir.
Without objection,
Correct.
Not from the state, Judge.
small case B.
You already grabbed it. I mean, I'm not going to tell you.
And then this is a class A misdemeanor, everybody? Well, class B misdemeanor.
The intent was the B. Yes, yes, sir.
Well, the problem is there isn't a class B misdemeanor under that that statute, under that section. So we're not, it's not a lesser included under there. I think what y'all need to do is file information on it, on a Class B under the Controlled Substances Act. Because I think it's a landmine waiting to be, I mean, y'all aren't going to do anything, but somebody later on, somebody could challenge it. I think it's an issue.
Even with an oral amendment to track the statute under controlled substance, Judge.
Well, you're now going under a charging instrument you're not working off the indictment from the grand jury. If there was something under this indictment that we could do, but it's.
Oh, one other thing, Judge, and I don't mean to be the dead horse. We'll let this go after this. After I make this pitch to the court, what if we do the 3811? Was it B that you were thinking? And because it doesn't that.
Yeah, that's right. But there is not.
But there's no misdemeanor there. But what if we did an attempted under that one? Would that get us to a misdemeanor?
That would give us to a state jail.
Okay.
30.
And then with state jail, could we punish it as a misdemeanor, Judge?
You can do
Then that would give.
44B if you want to.
Yeah, I'm just trying to move the case, Judge. I'm all about moving cases.
That's 44B, I mean, do this week, because
See, we're working on 3811 and 31. It doesn't fit.
Yes, sir.
The punishment range that the statute sets forth is too high.
We can do an information, Judge. I just.
We're just trying to do it.
Yeah, she's got 132. She's got 132 days jail credit, and under the facts, under the circumstances,
What we can do,
it is not.
could you get an information done today, and then we'll bring it tomorrow morning, and then
I don't know the answer to that.
I know you're busy, but we could bring her just as soon as an information is ready.
Yes, sir. This is not the kind of crime of the century, judges.
I know, but it's still, we're dotting the i's, crossing the
Yes,
t's. It's still important.
It is.
And it's misdemeanors have their place
Yes, sir.
according to the legislature. But the quicker you can get it done, we can come in and so she doesn't have to. And it's for time served, right?
Yes, sir.
Is that what y'all are trying to do?
Yes, we're trying to. She's got 132 days jail credit, Judge, and under the circumstances, I think she's. I think that's justice.
Here's what's her bond right now? Let's just, we gotta get it done just right under the, crossing the i's, crossing the t's, dotting the i's, which may take more than a couple of days. Okay. Where's your home, ma'am? Where's your home?
I stay in Houston.
All right, if I can give you a personal recognizance bond so she can be released, any objection to that?
No, Judge.
You're gonna have to report. If you fail to report, the deals are off. We're gonna have to report back here for a plea. And we're gonna set it for, you need to be back up here, because I'm gonna release you on a personal recognizance bond, so you don't have to post a bond anymore. But you have to report back. Can we get this done in 2 or 3 days?
Yes, Judge.
I'm here Thursday, so we can.
Set it for Thursday on the docket. You have to be here by order of this court at 9 o'clock, okay? We're gonna give you,
The other misdemeanors that I
I don't know what you're talking about now. I'm just talking about this case. That's all I know about. I don't know what you have otherwise. I'm talking about disposing of this case. And then you come in, you plead, time served, and then they would put you into I think they have to check you into the jail, and then you get released and you've done your time. But we would take care of this case. I don't know what your other cases are. That's not in my court. You've got to figure those out. I'm just talking about disposing of this one
if
here.
I stay incarcerated though, they'll call me out.
They'll bring you back Thursday if you stay. Yeah.
Where we set this for Thursday at 9 o'clock. Then I'm going to set a personal recognizance if she can make it. If she can't, we'll, because of the other bonds that she has to, or the other holds, but we'll dispose of this case on Thursday.
In the end, she gets released on a personal bond, comes back Thursday, pleads to the lesser charge, and gets credit for time served. All that legal back and forth for a misdemeanor? Follow for more of these real courtroom moments where the paperwork almost blows up the whole case.
And you'll get time served, and then that will be finished, completed, and then you can not worry about this one. But be here on Thursday, one way or the other. Okay, if you're released, you have to be here at 9. If not, you'll be brought here at 9, okay?
Thank you, Judge.
Thanks, you know, very much. But I just saw
Judge, did you? Now, did you want to see Mr. Atkinson with Mr. Lewis?
Okay, Marvin, come on up.